You're back with the PI show, and we're discussing a topic that concerns all working people, injuries arising from employment. Tony, we've got a few interesting cases. The first one, I think, is a case of Mr. Michaels. And
yes.
He was a university lecturer, and he was employed by Victoria University, but he was in between jobs.
That's correct.
He had a series of contracts, and one day he was just browsing, as I like to do, browsing in a bookshop, just looking at books.
Are you alluding to something?
No, I had a heart attack.
Jeez, that's not good.
Had a heart attack. And the issue was, this was in April 03, and the issue was whether that was in the course of his employment. He wasn't employed. He was starting his contract 10 days after the heart attack.
But what happened was this, it was a short-term contract and he couldn't possibly prepare for these lectures that he was going to give in the time that he had, you know, under his contract to actually... it was foreshadowed by the employer that he's going to do it in his own time. So the preparation was part of him delivering his lectures, and so the court said that his heart attack, because it happened during the time that he was actually preparing for these lectures, it was in the course of your employment.
And, all right, well, and this went to the Court of Appeal in Victoria, and it was determined it was in the course of employment, even though he wasn't actually employed on the day. They stretched it out a bit.
Well, I mean, they said that there's no way he could possibly prepare in the time that he was given in his contract. So
it was an incident or part of.
Yeah.
Or,
it was foreshadowed by the employer that he had to do it outside the course of his usual hours.
And why was it important that they establish it was in the course of employment?
Well, Harry, because it's in the course of employment, it means that he's entitled to his loss of income, medical and like expenses, and if he dies, I mean, there's a significant...
A widow's benefit?
Benefit, yeah, if he's got dependents.
And 98C?
Yeah, 98C, possibly. With the heart
attack?
It's a bit difficult, but, you know, there's a lot of benefits here.
So that's the reason why he...
How old was he, Harry?
He was in his
because the
50s.
thing is, yeah, so in his 50s, if he can't go back to work, because it sounds like he's got a nasty heart condition going on there, I mean, he's got, you know, expenses covered for life, essentially, and he's got loss of income up to 65. So it's a pretty substantial benefit.
But you know, work is extended in that case. There's another case where
it's beneficial legislation, so the judges generally try and stretch it a little bit to help the injured worker. Yeah,
well, there's a lot of cases that courts have considered over the years. For, you know, this has been a live issue for many years.
Many years.
But there's a recent case went to the Court of Appeal. This was more connected to work in some ways, but it was it happened on a farm.
Yep.
There was some delivery of hay, and one of the people who lived adjoining to the farm objected. He came up and confronted the manager of the farm, and the manager of the farm had some words to him, and then there was an assault.
Yeah, it was an interesting case because the manager of the farm was a fellow called Bailey who was delivering this hay, and there had been a lot of issues with, you know, as to where they dropped the hay off and all sorts of things.
It was blocking the road, I think.
Yeah,
it was blocking
an ongoing saga between these Bailey and Martin. And on the day in question, I think what happened was Martin threatened to hit Bailey if he doesn't take off, and Bailey said, "Look, I'm going to drop this hay off if you like it or not." So Martin threatened to come over the fence, and Bailey said, "I wouldn't do that because if you do, you'll sue me because you got blackfellow in you." So it was a bit, you know, comical to some extent, but he thought it was racial. And
it was a racist remark.
Yeah, he got upset, jumped the fence, and before you know it, they're into it, you know. So,
well, he ended up, Bailey broke his leg.
Well, you know, that's what happens when people start fighting, Harry. Someone gets hurt. But,
so Bailey's leg was broken, and I think the issue before the court was whether Bailey's injury was in the course of his employment.
Well, the court found in his favour because of the fact that he, you know, he was delivering hay when this incident occurred. So
he was supervising the delivery of hay.
Yeah.
But the judge in the first instance said that the racist remark of Bailey that triggered the whole event was outside Bailey's employment. You know, that Bailey was abusive, and Martin jumped the fence and assaulted him. But, you know, the court said in the first instance that the racist remark wasn't part of Bailey's employment.
But if it wasn't for him having to deliver the hay and the issue about whether he should drop it off or not drop it off, that all was
that was
caught
a
up in the whole
context.
thing. Yeah, it was in the context that it was in. Just shows you, Harry, that when you're dealing with these sorts of matters, it all turns on its facts. I mean, you don't have to change the facts by much for him to lose a case.
Yeah,
So
interesting you should say that, because in the Court of Appeal there were 3 judges, 2 found that it was in the course of employment, and there was quite a strong dissenting judgment which said it wasn't in the course of employment. And the judge who reviewed not in the course of employment, reviewed 28 cases that around Australia since the 40s that discussed whether things were in the course of employment or not. A lot of the cases turn on assaults.
Yeah.
And whether assaults and fights and arguments and threats that are generated from people disputing matters that are really outside of work.
Yeah, look, they're provoked, they're called names and all sorts of things. But more often than not, I mean, you're thinking there was a classic one of the barmaid that threw the glass and hit the guy in the eye.
Yeah, there's a case where, the barmaid, that was a vicarious liability argument as well, whether that was the employer was liable.
It just shows you that when you're dealing with these sorts of matters, it's important to get the advice of a lawyer, because they're very complicated. They turn on their facts.
But in Victoria, the government changed the law in 2003 following a court case of Hedgedus. And Hedgedus was sitting in a lunchroom.
Chopped his finger.
And he cut his finger. It was a very minor injury. He was peeling some apple.
Peeling an apple.
Cut his finger. And the argument was that in the course of employment, because employment had nothing to do with him cutting his finger.
Well,
the court found it was in the course of employment, and then Parliament then changed the law and said work's got to be a significant contributing factor. And if it's not, you can't get any benefits.
I think we've got to go on that break, Harry.
So, look, whether you're injured in the course of employment sometimes is a very, very tricky question. Yeah. And as Tony says, get legal advice because benefits can be considerable if it's found in the course of employment. We're going to a short break and coming back with Viv's mailbag. But before we do, we've got to thank Tony for shouldering the burden today, and we hope you enjoy Viv's mailbag. Keep sending queries in, and we'll be back after the break. Thanks for watching.
Thank you.